All right, I see we have people starting to join us. Welcome. I'm Lisa from the Law Library, and I'll just be doing a quick introduction today and then turn things over to our speaker, Judge Lomayesva. We also have Gabriella McGee here from NALA, and she's going to be doing the introduction of our speaker today. So thank you, Gabriella, and for helping put this together.
Of course.
And I'd like to give some great appreciation to NALA for co-sponsoring this event today. I really enjoy working with the specialty bar associations and groups to put together programs like this, and I really appreciate the partnership. Hopefully we have some NALA members joining us today. So let me just say a couple of quick things, and then I will get to the program. So as far as CLE credit, this of course is a CLE presentation today. Those of you who are showing up that appear in the Zoom report I'll be pulling up later will get a CLE certificate by email this afternoon. So be looking out for that. And then if for any reason you don't get that, you can get a hold of me, lfoster@sdlawlibrary.org. And let's see, Q&A. So this is an interactive presentation today. You will be able to ask questions of Judge Lomayesva. We will hopefully have some time at the end for her to answer those questions. But if you have questions, feel free to post them by typing into the Q&A function that you'll see on your screen here. You'll see a little icon with two speech bubbles that says Q&A. That's the appropriate place to put questions. And one of the nice things about that feature in Zoom is that you can post them either with your name or anonymously, whatever you're more comfortable with. And then I think the only other thing I had to mention is that you will see a link to a survey at the end of the program when you're leaving it. If some of you could take a few minutes to take our survey, we'd always appreciate that and getting feedback on our programs. So with that, I will turn things over to Judge Lomayesva and to Gabby McGee.
Good afternoon, everybody. And thank you again, Lisa, for helping us organize this and allowing us to co-sponsor. Like you said, my name is Gabriella McGee. I'm from the Kuya Band of Indians, which is in southern Riverside County. I'm a member of the NALA board. And so before we get started, I want to do a little plug for an upcoming membership mixer that we're having. If you're interested in joining NALA or interested in learning more about what we do, we're having a membership mixer on February 2nd at 6 p.m. at Public House 131 in the Mira Mesa area. And I'll drop our email in the chat in case anybody wanted to get more information on that, or if I said that a little bit too quickly and you need the dates and times again. So today we have Chief Judge Devon Lomayesva presenting for us on the history and law of the American Indians of San Diego County. Chief Judge is a member of the Ipai Nation of San Isabel, and also the Chief Judge for the Intertribal Court of Southern California, which she'll be talking about more today. She also has her own practice representing tribal governments and their businesses, really focusing on protecting tribal rights and their interests. So without further ado, I'll pass it off to Chief Judge Devon Lomayesva.
Well, thank you, Gabby, and good afternoon, everyone. I'm excited to be able to present for you today a topic that many lawyers don't get a chance to listen to. So I hope you find it interesting and helpful, and to see that there are many, many intersections between the practice of federal Indian law and tribal law that many of you might not have realized at any other point until now. So we hope that this is something just to enhance your practice and to learn a little bit of history as well for those of you that are here practicing in San Diego County and within California at large. So I want to spend a little bit of time on the unique history of California Indians. California Indians did not experience the same history that we are taught in schools. We were not first invaded by the Pilgrims. We don't have that history. Our history started with the Spanish, and that's where the mission system came in. And after that period transitioned, it was into the Mexican period, where the rancherias and those types of systems were the rule of the day. And then eventually the American period during the gold rush, which was, pretty much clearly the worst chapter for California Indians. So within the American period, there were some historic times, periods with the Treaty of Guadalupe Hidalgo, which drew the Mexican-American border, and the Treaty of Santa Isabel, which included numerous tribes from San Diego to designate tribal lands for them. And then the Act for the Relief of Mission Indians in the state of California, which, as any of you that may have looked at that, or you can easily see through history, it really was not anything to do with creating relief for Indians. It was actually to legalize indenture and essentially slavery for Native children and Native people. And it wasn't until years and years later that some of these laws were repealed and the reservation system came to be. So as I mentioned, the Treaty of Santa Isabel is one of the most prominent treaties that was passed here, negotiated, I should say, that came out of a commission from the Department of the Interior, where the issue of the conditions of Indians was known, and there was a decision that they needed to be dealt with. And so, including the Treaty of Santa Isabel, there were 18 treaties that were negotiated within California. And that was done by 3 different agents that came out and were known as treaty commissioners. So after those treaties were all negotiated, they were sent back to Congress, and unfortunately they were never ratified. And that fact was not known to California Indians for many, many, many years later. So they had been living on lands that they thought were theirs, to come to find out that actually weren't theirs legally. And once that fact got around and, everyone knew, then it just caused further loss of land, and, it was open season to come and remove tribes even further. And so it wasn't until 1875 that President Grant issued executive orders for 9 reservations in San Diego County, including those that you see here. Oops, sorry. Some of these you may not recognize because they are no longer reservations or have evolved into a different type of trust land. So you see those here that are familiar, a little bit different spellings. The Sequan is obviously spelled different. Inyaha Kashma is actually one reservation, and then Potrero, Rincon, and La Jolla are now, those are separate tribal governments. And then Capitan Grande now is still reservation land, but that's the Barona and Viejas bands that came out of the Capitan Grande area. So there's essentially 3 reservations. Right. So I'll kind of go through these a little bit quickly. These are the dates in which the tribes in San Diego County were established. And so now you'll start to see additional reservations that you might have been aware of. And it was all during kind of this time period, the last, quarter of the 1800s. And I have a few more maps that we can kind of see. Here's just some additional reservations that continued to be recognized. So right now, this is as 2009, but these are still the same reservations that are in San Diego County today. And you can see that list here, about 17 of them. And just kind of in comparison to the rest of the state, you can see where the concentrations of reservations are, and the not surprised lack of reservations in the coastal area from LA up the coast until you get a little bit more to the Bay Area. We do have a lot of unrecognized tribes that are still in those areas, but no federally recognized tribes. San Diego is composed of primarily 4 tribal groups. Many people refer to the Ipe or Tipe speaking people as Kumeyaay. It's really split up a little bit more than that. That's kind of the common nomenclature today. But in the northern part of San Diego County, we are the Ipe, also Ipai people. Down more in the East County, there's the Tipe or Tipai, And then the Kumeyaay people also are in that area and extend down into Baja California. The Kumeyaay people actually extended all the way down into Ensenada. And so as you can imagine, when the Mexican-American border was drawn, it increased even further havoc on tribal communities and families. And that exists today because the Kumeyaay people that live in Baja California are not readily allowed to just cross the border. And so that's just caused further divisions in our culture and our tribal governments. There's also the Luiseno people, the Payam that compose a lot of the reservations in northern San Diego County. And then also within northern San Diego County, you have the Kupa, the Pequeño, and you have the Los Coyotes band, which is also Cahuilla, Mountain Cahuilla. So just one more look at the map. I find it always helpful to kind of see the areas that we're talking about. And by looking at this, you can really see that, you know, the tribal presence is still in and around San Diego. And so, you know, our tribal people also live in and around San Diego on and off the reservation. And when you live off the reservation as a Native person, you know, many of these laws still apply to you. So that's something, as we'll see later on, if you work in, you know, family law or trust and estates or taxation, the fact that your client doesn't live on the reservation doesn't mean that you don't need to be aware of their status as an Indian person, because it follows them and those considerations still need to be made. This is just a quick slide on the different language groups that are in San Diego County. It's really broken up into, you know, a couple of main language groups, but of course the numerous dialects, and I'm not a linguist, but do have a love of language, and it's just something else that's important for our culture to understand that we do still have our tribal languages. Just on culture, a lot of the tribes now are, you know, have been for many, many years, you know, obviously still practicing our culture, but there's definitely been a revitalization where now there's dozens and dozens of tribal gatherings. This is a picture here of the Santa Isabel gathering many, many years ago. And it's just great to see that that's happening and that those things have not been lost. Let's see. It's just some references to some of the information that I've shared with you here on history. And I really encourage you to look for other resources to have more of an appreciation for the history of the tribes in San Diego. These are my kids many, many years ago. They're 19 and 20 now, but this is a picture at the village of Casoy, which is now known as Old Town. That was a very, very important village. It's right under the Presidio, which is one of the, you know, essentially the first fort that came about. The Spanish, many, many, many thousands of our people died here, disease and for other reasons. So it's a very, very historically and culturally important place for us as Kumeyaay, Ike, Degeno people. So I want to move now to the legal part of this, which is to talk about tribal courts and focus a little bit on the intertribal court. So generally there's two types of courts. There are generally tribal courts and CFR courts, which is Code of Federal Regulation courts. There's approximately 400 tribal justice systems throughout the country. Tribal matters are heard through either an individual tribal system or through a traditional court. Tribal courts look very different, just even within the county. The Paula Band has their own tribal court, and then just over into Riverside, there are other tribes in that area with the Morongo Band, Agua Caliente. They also have their own courts, and other tribes, you know, within San Diego, Riverside, and even throughout California are also members of our court or use our court for limited subject matter. So again, our courts, many of us follow a traditional Western model. but also with traditional custom and tradition components, including just customs and traditions that are unique to our tribes here. We had our own means of dispute resolution, and many of those practices are still here today. And depending on the specific tribe, those are implemented into the work that we do here at the court. There's also many tribes that have peacemaker, talking circle type provisions within their tribal codes. And we do offer that here at the tribal court as well. It's essentially mediation, but it involves custom and tradition. As I said, the tribal courts are run independently by the tribal governments. Tribes without their own courts per se can use courts of Indian offenses, which I'm not going to spend much time on here because that's not really applicable to California. There's a couple of tribes that are on the California-Arizona border that do have CFR courts, but that's something that, you can definitely look at that more if you're interested. So here, I will focus on how our tribal courts look here throughout San Diego in California. Tribal courts hear matters under tribal, federal, and state law, and many times people are confused by that. But tribes interact, on the reservations and off the reservations. They have businesses on and off the reservations. As far as the state law, a good example that I like to provide is that many gaming tribes that have gaming facilities have entered into tribal state compacts with the state of California. So there are certain provisions in those compacts that require some form of dispute resolution. And so the tribal court, essentially, if the tribe has asked them to hear those matters, such as tort claims or employment discrimination, in essence, we will be following state law, which is their tribal state compacts. So there are over 20 tribal court systems in California that serve approximately 40 federally recognized tribes. There are 2 intertribal courts, the InterTribal Court of Southern California here in San Diego, and the InterTribal Court of Northern California, which serves a handful of courts up in the northern part of the state. All of these courts are civil in nature. There is currently no criminal jurisdiction being exercised, but I say that with a footnote, because as I speak, there are tribal courts that are entering into joint jurisdiction programs. I know the Yurok tribe has made amazing strides in partnering with their county to provide joint jurisdiction opportunities in criminal in nature, and the Shingle Springs Band of Miwok Indians have done wonderful things with joint jurisdiction with dependency courts. And there's so many examples, and I don't pretend to know all of them, but tribal courts really are making strides in making partners with our counties so that we can provide the best services available to tribal members that live on and off the reservation. Let's see. A couple of other items: domestic violence restraining orders under the Violence Against Women Act. This is obviously a federal law, and so those domestic violence restraining orders issued by tribal courts must be given full faith and credit. And so, as I'll talk about later, with regard to our court, we have a working relationship with the San Diego Superior Courts, and to ensure that our domestic violence orders are being inputted into the CLET system. And then we also have a tribal access program where we're ensuring that our orders are being put into the federal system, so that, if one of these orders is violated, regardless of which law enforcement agency responds, they'll be able to find our orders in whichever system. There's a handful of tribes in the InterTribal Court of Southern California that have a civil citation system where, under their peace and security or law and order codes, they are issuing citations to tribal and non-tribal people alike for various civil offenses on the reservations, anything from trespass to petty theft to, drinking in public, possession of illegal drugs, speeding, those kinds of things in a civil context. So they use our court for their civil citation calendars where persons are ordered to pay fines, do community service, or enter treatment programs, or a combination. This is just a list of the tribal courts that are in California. And you can find more about these courts on their individual tribal court websites or on the Judicial Council of California section on tribal courts. I encourage you to look at those. And again, I just mentioned this, just resources to find out more information about tribal courts. There's plenty of information that you can find just simply looking on to the internet. And then the other one I wanted to mention is the Tribal State Court Forum, which is a forum of tribal and state court judges that come together to talk about issues primarily centering around child welfare, but other issues that are of mutual concern to judiciaries. Here is just a picture of the page where you can find that information. I think that's always really helpful for people to be able to look at that. We have many lawyers that obviously aren't familiar with tribal courts. And so if you find yourself coming into tribal court, it might be a good idea to kind of do a little bit of research. And this is just a great resource for you to do that. And here's the Tribal Court State Court Forum that I mentioned. So just a little bit more about the InterTribal Court here. This court was formed in 2002 under the Southern California Tribal Chairmen's Association via a grant that was primarily for child welfare matters. And then in 2006, the court became an independent entity. The purpose of our court is to provide member tribes with an independent judiciary that provides culturally sensitive and takes into account customs and traditions of the tribes in order to resolve the various disputes that may arise on the reservation or off. The InterTribal Court serves as a consortium. So what that means is, even though it's a consortium, the court only uses the laws of that tribe. The tribes do not share their laws. It's operated as an independent court when we are in session for those tribes, but we do share court rules, rules of evidence, and it's just a sensible way to pool resources when several of our tribes have very small memberships for many of the historical reasons we talked about earlier. And so it's not always possible to have the staffing and at some point the jury pool. Tribes are looking at the future as to criminal jurisdiction, civil jury trials, things like that. So, it's much more sensible and resource driven to be able to have this intertribal court model. Tribes join our court via an intergovernmental agreement. They have representatives that are appointed to our Intertribal Court Judicial Council, who is the governing body of the Intertribal Court. As I said, the jurisdiction of our courts defined by our members. They confer jurisdiction on us for a variety of different ordinances, codes, whatever tribes refer to those laws as. And there's just a whole host of issues that you can see here that we hear. I mentioned the public safety issues that come through our citation calendar, tort claims, environmental, family law, a lot of conservatorships lately, enrollment, exclusions. We also handle evictions for the All Mission Indian Housing Authority that serves a number of tribes with as its Indian housing agency. We also have a handful of tribes that are maybe one or two subject matter. So they've joined our court via a memorandum of agreement. And as I mentioned earlier, we also offer arbitration and mediation services, which we are right now looking into building up our mediation services to include more culturally relevant types of services so that we can serve our tribal people in a way that's less adversarial than the traditional Western court model that we offer. And we also have an appellate court, a 3-panel appellate court that reviews our trial court decisions. We also have added a couple of more social services type programs to the court in the last couple of years. And that's our youth peer court that serves youth in middle school through high school, but we're also in development for a transitional court where we'll serve, which I still consider youth, ages 18 to 21, which more and more courts are doing these days to address that gap between adulthood and 21, where there's still a youth component there. So we're looking forward to growing that. We also have the Agave Project, which is a project developed through the Office of Victims of Crime, which is aimed at supporting victims and their families. And we offer primarily services devoted to helping persons navigate our tribal court system. They help filling out, restraining orders or other court documents. They help people prepare documents and locate documents that they need to. We also help with just a variety of issues that come to the attention of our programs via our community, whether it's education matters, special education, things like that within the schools, as well as just providing services and resources to referrals or other programs that we're partnering with. And also the Agave Project supports our youth court on the social services end. So we're really excited and proud to have those programs functioning now within the court. I already mentioned that we function essentially as a circuit court. We have our main courthouse located on the Rincon Reservation in Valley Center, but we also travel to tribes if that's what they prefer. So we have dedicated areas within the tribes. We travel, for instance, to the Sequan Band of the Kumeyaay Nation. We travel to the Viejas Band of Kumeyaay Indians, as well as the Torres Martinez Desert Cahuilla Indians and other reservations. It just depends on their preference. I don't know if this stat is aging now, but on average, we hear about 600 cases a year, and I think that number is actually probably a little higher at this point. This is our court judges. We have a variety of court judges. Some of us are members of tribes, others are not. Some come with Indian law experience, but we have a really great wealth of experience of, those that have worked in district attorney's office, litigation, Indian law, family law, torts, you name it. Our judges have experience all over the place, and that's exactly what we want. So we have the expertise to handle cases that come through. This is just what our staff looks like. We are definitely understaffed, just like everyone. We are still out there trying to hire many of our positions, but these are our essential positions that we have within the court: our administration, our youth court, and our Agave Project. These are a list of our member tribes. You can also find out more information on our website, which is intertribalcourt.org, that has more information about just the various programs. You can also find on our website all of the tribal law. Sometimes if you click on the tribe from our website, it will take you to the tribe's website, where they have their law out there for anyone to see. So I kind of mentioned this already. This is just another example of the various types of matters that we hear within the court, which, as you can see, is anything that you would see out in other courts, but then things that are very specific to tribes, such as the exclusions and enrollment matters, just to name a few. So I wanted to spend a little bit of time on just a couple examples of the intersection of tribal and state courts. The first example I'm going to talk about is tribal customary adoptions through the Welfare and Institutions Code, but also a little bit more in depth on the domestic violence protection orders under VAWA. So for those of you that might practice in dependency, tribal customary adoption was codified in the Welfare and Institutions Code, which is essentially another placement preference where the tribe can say that instead of a guardianship or a traditional state court adoption, that they want the permanent plan to be a tribal customary adoption. The reason that that was put forth is because tribes that didn't transfer jurisdiction because maybe they didn't have a tribal court, were being forced to make decisions that could be detrimental to tribal children. If the parent-child relationship was severed, which is the normal course of things when you go to adoption, that termination of parental rights would result in issues sometimes with enrollment, and also issues of being able to maintain tribal property on the reservation. And that was seen as a huge hurdle. And so the tribal customary adoption accomplishes many, if not all, of the same goals of permanency through adoption, but it doesn't sever that relationship, which is counterintuitive to, I would say, every tribe's belief in California. And so there would be able to be the opportunity to maintain the connection with the adoptive parents and those legal rights that tribal children had by choosing this as a permanent plan. So the tribe has to elect to do this. And when they do that, they have to have a tribal court order filed with the dependency court. And that language usually includes very specific tribal language and custom and tradition. For example, as I have here, maintaining contact with the tribe, participation at tribal events and ceremonies, and also family visitation. Many of our Native children are adopted by our family members, and if not, those extended family members or other tribal persons that are okay or supportive of maintaining a presence with that child or children in the tribal communities, but that's not always the case. So this permanent plan, as we call TCA, allows that to happen more readily. And so as far as where the tribal court comes in, when those tribes are in dependency and they've gotten to that point where they need the order issued, the tribe will file with us a request for a tribal customary adoption. We will have a hearing in accordance with tribal law, and then we will then issue that order that goes back to the dependency court. And these have been very successful. And I've done these on the judicial side in the tribal court, but I also still practice in dependency court and have done these on the attorney side. And the system works really well with regard to this, and it's been a really great option for tribes. Again, on the Judicial Council, California Courts and Judicial Council websites, you can find more about tribal customary adoption. And it's just something that is a really wonderful tool. So with regard to protective orders, as I said earlier, these orders must be provided full faith and credit. California law and VAWA mandate that full faith and credit. Despite that, there's been many, many reasons why that hasn't been the case. Too often, tribal courts are looked upon as, they're not real courts. They're just, the tribes always win. Mickey Mouse courts is something else that I've heard. It's just absolutely not true. Our tribal court here requires our judges to be attorneys in good standing within the jurisdiction that they have passed the bar, or whatever number of jurisdictions. Many of our judges are barred in, were barred in other tribal courts as well before they came to be judges. So our judges are, qualified as any of them. In order to practice in our court as an attorney, you have to be a member of our bar, which requires a number of items to be completed. So our tribal courts are courts. So when we issue an order, there was unfortunately those first responders, mostly law enforcement officers, were looking at our orders and saying, this doesn't look like an order, this doesn't look real, this doesn't look legitimate. So they weren't enforcing them and people were getting hurt. So probably about maybe 20, 25 years ago now, at least in San Diego, a lot of the legal services providers here, including California Legal Services and many entities that were working with this tribal court from the very beginning, wanted to make sure that this was not going to happen again. And so there's a big effort to work with the courts, also through the Tribal State Court Forum, to be able to ensure that our orders were going to be enforced. So the courts, at least our court, has made a concerted effort to make our orders look like any other court order, even though we don't have to. As long as we're protecting the people that we are representing, we're going to protect by issuing those orders. Fine, if it takes making the order look familiar, then that's what we're going to do. And we in fact have done that. And I think there's been more success as tribal courts up and down the state have communicated more and more with those, first responder, law enforcement officers. We have regular meetings with them to ensure that, as new people come in, whether it's the sheriff's, highway patrol, local law enforcement and tribal law enforcement, that they're talking and that everyone understands that these orders are going to be coming. The other hurdle has been getting them into the CLET system. There's been issues with the larger law enforcement bodies that, make it difficult for access to those systems. But a lot of progress has been made. As I said, with our court here, we have worked to develop our relationship. So when we issue these DV orders, we're filing those DV 600s and all the requisite forms and information that are required to get those orders recorded and put into the system as soon as possible. And then on the federal side, utilizing our tribal access program that a handful of our tribes have been approved for, so that our court can issue those into the federal system and not leaving any gaps, so that when law enforcement needs to confirm these orders are still valid, they can find them. So next, this is a document that you can also find, again, Judicial Council, which is a wonderful resource, that just talks a little bit more about recognition and enforcement of tribal protection orders. So I encourage you to look at these if that's something that is in the realm of what you do. This is just the rest of the handout. So just a little bit more about the Tribal Youth Court. We are working now with the District Attorney's Office, probation, the juvenile court, as well as a few law enforcement agencies to be able to partner or to be transferred cases that are appropriate for diversion for Native youth in San Diego. And we have really enjoyed developing those partnerships. We're looking at MOAs being signed very soon. We already have agreements with many service providers that will provide direct services, such as our Indian health providers, domestic violence providers, school districts, all that are vital in our youth lives. We have some schools that have very high Native populations within San Diego, and we want to make sure that we're catching our youth that start to go down those paths early on, whether they come referred from the schools, from the tribes directly through their law enforcement citations, from individual, law enforcement agencies, or the probation department, or the district attorney, or even a case that is in the San Diego Juvenile Court, that we can be a partner for Native youth to provide those culturally appropriate options for diversion. So we have very high hopes and expectations for this program. And you can also find out more about our youth care court on our website. The Agave Project I talked about. This program, again, will also be supporting the youth court, the social services end. We wanted to make sure that, we all know that court clerks do not give advice. There's not a lawyer program that we have to, refer people to. So we wanted to make sure that for our court specifically, we have people that can help them navigate our system and maintain the integrity of the court. So this program operates in a different building on site and works to provide that advocacy, guidance, also with court systems outside of the tribal court. Oftentimes, those issues aren't right for tribal court, or it's just, there's no jurisdiction with the tribal court. So we help people get to clinics or other resources that can help them get the education and information they need. And possibly, if they need attorneys, we are using the Lawyer Referral Service. And we're actually looking to get more and more of the attorneys that are barred with our court to provide pro bono services as well, so that we have a mechanism for people to have everything they need to essentially have due process and fairness within the tribal court. Let's see, this is kind of things I've already said, but this is the various types of services that our tribes receive when they're a part of our court. And, just like all of the courts we all practice in, right? So, and just helping to provide more and more services as well. That is all I have. And I think I have a couple of minutes for questions. So Ahai, thank you very much. And I will stop now.
So I'm just coming back in to help out with navigating the questions here. And we do have one from Kathleen who wants to know if the court has a public records section or library for non-tribal public members of the public. And I had a similar thought as well. I was wondering if people are looking for some kind of access to court records or information, how do they do that?
Yeah, our court rules have provisions for the sharing of court records. We do operate, a little bit differently, but there's absolutely provision for that. We have people requesting copy of their case files. We have, people making records requests for whatever reason. Of course, just like any other court, there's certain areas that are confidential, juvenile, child welfare, conservatorships. But yes, we absolutely have provisions for that in our court rules.
So we have plenty of time for questions, everybody. Please type in your questions, anything you have on your mind. Here's one from an anonymous attendee. Could you offer more information on how lawyers who want to offer pro bono services can connect with you? That's a great question, and maybe even what kind of services might be needed.
Yeah, absolutely. Well, please contact us. On our website, you can contact us, or my contact information might be on here as well. But we actually did a Power Act panel, myself and a couple of other tribal judges, and we had a great response from that. And we had a number of private attorneys contacting us to see how they could help in the domestic violence area. So if you go on our website and you find the section of the attorneys that are barred, I can't remember how many we have, but we have several dozen attorneys. There's a section on there that indicates if they are willing to consider pro bono work. So that's such a huge need. I think mostly that need comes in conservatorship cases where we don't always have attorneys to represent the conservatee or proposed conservatee. Child welfare, of course, in our system, most of our tribal codes, there's not a requirement for parents to be appointed an attorney like there is in state court. So with that, we're trying to explore more and more for pro bono, but also our lay advocate program that our Agave Project is looking into and going to be getting training in so they can become a lay advocate. So please contact the court. There's plenty of ways to get a hold of us, but those are probably the primary areas. But you just never know what someone may need, an attorney for. So please follow up on that. We'd appreciate it.
So Marshall is asking if there's a referral service. I'm not sure, Marshall, if you're meaning an attorney referral service for people who are members of the Intertribal Bar. You can clarify if that's not the case.
Yeah, and if you're getting clarification, we do, if somebody brings in something that's clearly a tribal law, federal Indian law matter, we say, look on our website because those persons are barred here, have an awareness, look for pro bono or just call them. But other than that, that's our only service is, hey, look on our bar. Otherwise, it's lawyer referral service if it's something that, probably doesn't have to do with the tribal court.
And I imagine possibly the San Diego County Bar Association, through their own lawyer referral service, may have names of people who are specializing in this area as well.
Right.
So Kathleen is asking, I think this is a follow-up to her earlier question about a library or access to public records. She wants to know what is the location and where to get additional related public access to a library or a section to review. So again, I'm not sure exactly what you mean. Maybe at the court in Valley Center, is that where someone would go if they're looking for information?
Yeah, that's our headquarters. I mean, we don't have a law library here. That would be wonderful someday if we did have that. But certainly, excuse me, if there's certain resources that you're looking for, our court solicitor, I know, would be more than happy to provide different resources on Indian law, tribal law, and so that's kind of where we are right now. But certainly, we'd be happy to talk with anybody that's interested in learning more.
And if I could make a plug for San Diego Law Library, we do have some federal Indian law and tribal law resources in our library, both in print and within our databases. So feel free to come and see us if you're looking for information, and we can possibly help in that regard too. So our attendee who was asking about pro bono opportunities wants to know, is there any need to have expertise in the public benefit services and programs to do that?
Expertise in public benefits? That does come up. We have a number of persons that, are on tribal TANF or other public benefits. And, sometimes they contact us and, that's something that, again, we can't provide legal advice. So it's so specialized that it's hard to, you feel bad, right? Referring people out, just go find lawyer referral services. So it's wonderful when we have people and we can have that list so people know, what your expertise is. But absolutely, the vast majority of, our tribal people here in San Diego still live under the poverty level. And unfortunately, sometimes that statistic, is forgotten and thinking that, there's not poverty on reservations, which is absolutely not the truth. There's many of us that the reservations don't have electricity and running water, and we live off wells or generators. So things like public benefits are absolutely essential to, our tribal people. I mean, SSI and just everything that you can think of in there. So yes, absolutely, that would be a wonderful area to have expertise on.
So another question from Ross, he wants to know if you can recommend any good books regarding Indian law and practice in California.
Oh, wow. Well, there's always the famous Felix Cohen Handbook on Federal Indian Law, which is, the original and book that's still referred to time and time again. There's so many resources. For California, the tribes are so different. I mean, there's over 100 federally recognized tribes, and they all have very, very different law. But if anyone wants to contact us at info@intertribalcourt.org, those go directly to our clerk and our court solicitor. And our court solicitor knows all these resources, off the top of her head, and could be a great resource to provide that. But like you said, you probably have resources in your law library. But even just looking at the tribal websites and looking at their tribal law, you can really learn a lot about, how the tribes are operating and kind of how their governments are run.
Another attendee wants to know what type of environmental cases the InterTribal Court is handling.
So again, for tribes that have, environmental laws, codes, it could be anything. It could be, persons that are bringing, modular homes or trailers or RVs and are not hooked up to any connections. And so they're polluting the ground. It could be, people burning trash. I mean, any number of things. And those fall under, those are violations of tribal law. There's also many reservations that are what we call checkerboarded. So within the reservation, you have private fee land owned by, non-Indians who sometimes operate businesses that directly affect the water quality, air quality of tribes. So you see that, and then, I haven't really seen this, but I guess it's a possibility, but under the tribal state compacts, there are certain standards for the environment, and many tribes have environmental ordinances or provisions with regard to their gaming facilities or other facilities. So it just really, really depends. We see all kinds of different things.
We have an attendee who's asking that because they are unfamiliar with tribal court orders, what are the best ways to verify the validity of a tribal court order? Is there a phone number or an online service that you could use for that?
Well, my first response would be, don't always assume it's not a valid order. I mean, these are orders. But if it's an order issued by, the InterTribal Court, then you would certainly want to call the InterTribal Court and you would get a clerk who can verify those orders. With our domestic violence orders right now, one of the last things we're working on with our tribal access program is that, in order, we have to have 24-hour access to be able to verify those orders. So, our different law enforcement agencies, our tribal law enforcement agencies are, indicating who that will be and all that information so that, at any given time, if those orders need to be verified, pursuant to law, but then, they can be verified. But then other orders, absolutely, you contact us and you just contact the tribal court. That's, don't contact the lawyer or try to contact the judges directly. Just like any other case, you're not going to call up the judge, right? But sometimes it's interesting when attorneys are in tribal court, they kind of forget all the ethics and the rules that we learned in law school about, you don't get to call the judge and you don't get to ask the clerk to give you legal advice. And so many times we have to point people back to our court rules to understand that. And we give as much guidance as we can, understanding that, this is new to many people. And so we want to be as helpful as possible, but, we just ask to be treated as any other court and follow kind of those kinds of, procedures.
So we have an attendee who is asking if you could outline some of the essential requirements for entry into the tribal bar.
Well, it's fortunately right now not too complicated. We are looking at having a small bar exam. I know the Hupa tribe up in Northern California has a bar exam and it has some Indian law questions on it. I've never taken it, so I don't know exactly what's on it. But right now, it's essentially, we have an application, there's a fee, and, making sure that proof that you're in good standing with the bar, proof of malpractice insurance, and a recommendation letter from someone that is barred in our court. And that's pretty much the core. There might be a couple other things that I'm forgetting, but that's the core requirements. So it's not too difficult, but I think coming very soon will be some kind of, bar exam that might start off very small, just to make sure that, there's some basic understanding of tribal law. So that's it.
So you had previously mentioned that the tribal court applies customary practices. So we have an attorney who wanted to know a little bit more about what that looks like. Could you explain a couple of examples and, when those practices are particularly effective?
Sure. I think the most prevalent would be in child welfare cases, and many of the tribes that have children's codes have written that into their codes, that, there's tribal law, custom, and tradition. And that a lot of time goes to child rearing practices. For those of you that might do dependency work or maybe even family law, the reason for the Indian Child Welfare Act is because the way of life of tribal people was interpreted to be bad for children. And that's why our children were stolen for decades and decades. And so the custom and tradition is, a lot of times people want it to be something that's this glaring ceremony or something like that. And it's hard to explain, but it's just the way of life, oftentimes. And I guess an example is, the fact that a lot of the times in our communities, our children are raised by a number of people, not just their parents. And it doesn't even mean the parents are doing anything wrong. And so, a lot of times people just don't understand that. And so when it comes to placement, custom and tradition, we might place a child with, their fifth cousin instead of their father, because they're their family. And the tribe has the ability to do that. It's just a variety of different things, and it's very, very case specific. But I think child welfare is the most prevalent when you're talking about child rearing practices, when you're talking about the types of expectations, just like I talked about earlier with tribal customary adoption, our communities have, generations and generations of trauma. And, that's something that we haven't found out as communities how to solve yet. And I don't know if it'll ever be solved. But in the meantime, in recognition of this, tribes don't see that severing of that parent-child relationship. And so when these youth through the tribal codes are being placed within the tribal community, even though their parent had them removed because they weren't taking care of them, they'll have an ongoing relationship with their parent, and they'll be able to see that parent all the time, as long as that guardian, that family member, is keeping them safe. So, we have the ability to do that pursuant to custom and tradition under those children's codes. And, there's other things like land use. We have very complex land use laws on reservations, much in part thanks to the history of laws, federal laws in this country. So it's a jurisdictional maze just for the land itself. So, there's customary ways that land is passed down from family member to family member. But, even customs and tradition get, I guess they can be subjective sometimes. So there might be times where it's like, well, historically, we followed, you get 1 acre and you get to pass it on to whoever you want, as long as they're a tribal member. But in other situations, there might be something called family land, family holdings, that goes to the oldest son or the oldest child. There's just different rules that aren't written in our tribal communities. So there's been times where we've had to bring in those experts of the custom and tradition, and ultimately, the judge has to make a decision on which custom and tradition will be followed. So it's not always easy, but that's just, the beauty of being a tribal court and understanding our community. So I hope that provided some examples.
And I think that really illustrates why sometimes the state courts are not in the best position to handle these kind of cases.
And in fact, many of these matters, they aren't allowed to handle. And Public Law 280 is something that, we could have a month of webinars on and probably still not get it. But, that's caused even more jurisdictional confusion among tribal, state, federal, local governments. So, there are some things that there just is not jurisdiction for the state courts to handle. So the tribes have to handle them or else they won't be addressed. And so tribal courts are absolutely essential. And, I think you're going to see more and more tribes joining. We've had many, many tribes contact us interested in touring the court and looking at how we operate. And I know many of the other tribal courts up and down the state, like I said, that are doing amazing different things to address the priorities of their communities, and their counties are finding ways to make that work.
So we're really running up against the clock here, but I'm hoping you will just answer one more question, because I see that more than one person has asked this question. This goes back to doing research. Are there decisions of past cases that have been litigated by the court that are precedential, and how would attorneys be able to find those to research and review?
Yeah, and that's something, with, going back to the records and the law library and things like that, something that we're still developing. Some tribes, again, don't forget how unique California is. And for a lot of historical reasons, we were essentially told that we did not need tribal courts. And this was by the federal government, who's supposed to be our trustee, would not fund our tribal courts here. Because Public Law 280, you don't need it. But that wasn't the case for the reasons I just said. There's things that Public Law 280 do not allow state courts to handle. So we were left kind of with this emptiness that wasn't funded and wasn't endorsed. So tribes outside of California, Arizona, the Plains, just all over, they've had tribal courts, for many, many years, and are exercising criminal jurisdiction in all those, areas that we're not there yet. And some of them have robust access and records, and you can get those from their courts. We're not there yet. We're just a little over a decade in. But yes, there is precedential, cases that are used. And certainly, if you find yourself in a case with a tribe, again, going back to our court rules, you have the ability to request those. So those are available, but unfortunately, we don't have, kind of like a Westlaw or something where you can do that. Some tribes do, and they're actually using Westlaw or Lexis to do that. And so we hope to get there. But certainly, as I said before, the court takes very seriously due process, fairness, and transparency. And it just operates a little bit differently, which might seem uncomfortable for those practitioners. But at the end of the day, I think you'll see that most persons that come in see that we have a fair process and provide access as needed.
And again, I posted it in the chat, but as Judge Lomayesva mentioned, there is a way to contact the court at info@intertribalcourt.org.
Yes.
I think I got that right. info@intertribalcourt.org. Well, we're out of time, but thank you so much, Judge Lomayesva, and everybody who joined us today. I hope this session helped address some of this lack of awareness that exists in the legal community of the tribal courts. And I hope you learned something today. So thank you, everybody.
Great. Thank you for having me.